Okay, it is now 11:50, and so I resume the hearing.
So I wonder if I can just, I've been reminded by my team of 2 points that I should probably have made. I know it will take me a moment, but can I just make those points now? The first point is a point which I think is implicit in what I said, but I just want to draw the point out, that what I have obviously emphasised to you is that in looking at the mitigation, you have to look at it as a package, and you have to look at it its cumulative effect. Now, I've already made that point. But just the follow-on point from that is that is what is critically wrong in our submission with the analysis in the Waterman HRA, the 2020 HRA. Because although they acknowledge that, see 4.2.209 of the document, they acknowledge that in principle, and then the following paragraph as well, actually. They don't then, we say, do the exercise. They don't. What they then fall back on is the idea of a general 400-metre buffer. At no point in that analysis do you see an attempt to deal with, on the facts of this situation, the cumulative effect of those mitigation. And you can only understand the effect of this mitigation cumulatively because you can only, otherwise you end up saying, well, the problem with the green space is you have unauthorised points of access, and the problem with the fencing is you don't have green space, or whatever. You've got to look at it as a package. That's the first simple point I wanted to make. So we say that's why the Waterman HRA is flawed. And then the other point that I wanted just to briefly make is that we do detect a degree of inconsistency in the Council's approach to visitor numbers. Now, you've got, certainly in relation to H59, you've got the point that H59 up by itself is likely to contribute a pretty small amount of additional visitors. Not even 1 per hour, I think, but anyway, it's 1.2% increase. Striking, we suggest, to put that alongside the projections for some of the other site allocations. You can see that at 1.32 of our hearing statement where we set them out. So this is the breakdown of the 8 point whatever it is percent. And you'll see that collectively allocations ST7, ST17 and H56 are projected to give rise to a 1.6% increase, so greater than H59. But how do they deal with that? Well, you'll see that it's 1.36B of our hearing statement. Those sites, collective 1.6% increase, are not to be mitigated at all. Effectively, the Council says, sorry, where's that reference? And that's the HRA, isn't it? Yeah. It's 4.2.277 of the Waterman HRA. Well, that's too small to matter. We don't need to worry about mitigating that at all. If that's right, then consistency requires the same approach to H59. Now, the reason that matters is that it points up that what this case is really about is the impact of ST35. H59 is, even on the Council's view, or on the Council's view if one is consistent, a minor addition. And so debates about whether the small numbers of houses on H59 are 135 metres or whatever doesn't really matter. You're only going to have a real impact on the common if you can't mitigate ST35. That's a simple point I want to make. So thank you for that, allowing me that addition.
Mr. Elvin.
The first point is, if I can put it colloquially, although Mr. Bewley talks the talk, he doesn't walk the walk. His approach to the legal tests he revealed as being unduly lax when he said it's a moderately high or a reasonably high test. It isn't. It is the highest test applicable to any protected site in the United Kingdom. I'm afraid I'm going to bore you by taking you to the Wyatt case in a couple of paragraphs just to demonstrate that. Secondly, the test for land use plans under Reg 105 of the Habitats Regs is the same as the test under Reg 63 for individual applications. And indeed, you'd expect that to be the case because they both derive from the same paragraph of the Habitats Directive. They both derive from Article 6.3. And indeed, you can see in Regulation 61, using the language of the directive, it refers to any plan or project. Plans are treated no differently. So while I agree with him up to a point in his 5 propositions, you have to be very careful about how you approach this, because as he accepts, the whole matter is underpinned by the precautionary principle, which means the elimination of risk and the achievement of certainty. I'm sorry to have to do this, but Mr. Bewley says one thing, but his submissions adopt a laxer approach than is justified. Could I ask you just to pull open CYC 95, which is the Wyatt judgment? I apologise for taking you to a legal point. And it's the summary in paragraph 9, which starts on page 5.
If you'll bear with me just one moment. Yeah, sorry, which page did you say?
It starts at page 5. I don't need to trouble you with the first couple of paragraphs. There were issues in that case about the standard that the court applied.
Okay, I have that.
The first point is one which Mr. Bewley doesn't really focus on, which is subparagraph 3 on page 6, which is the well-established point that the expertise... Sorry, wrong one. Forget that one. Sorry, it's point 4, which is the significant weight to be given to the advice of the expert national agency, which in this case is Natural England. And of course, you can disagree with Natural England's advice if you have cogent reasons for doing so. All Mr. Bewley does is point to the information that is already before the inquiry and indeed before Natural England. Natural England has seen precisely the information that Mr. Bewley has referred to and has been consulted, and was consulted on the revised HRA, and has clearly read the hearing statement. Natural England does not agree with DIO's assessment, and Mr. Bewley's only reasons for seeking to depart from that is because his team disagree with it. That is not cogent reasons. There's no flaw in the material available to Natural England. They haven't just come in at the last minute. They have been involved throughout. Now, to turn to the actual test, can I take you to point 6 in the paragraph 9? If you'll see that it ends by saying the precautionary principle requires a high standard of investigation. And that's then picked up in paragraph 7, and you'll see it says the duty placed on the competent authority to assess there are no adverse effects doesn't need to be absolute certainty, and Mr. Bewley takes that too far. Must be satisfied there is no reasonable doubt as to the absence of adverse effects, and you'll see it then quotes, Sir Keith Lindblom then quotes the Waddenzee case. You're only entitled to authorise, and proposed development applies to plans as well because the directive applies to both, only if it is made certain that it will not adversely affect. This is the case where no reasonable scientific doubt remains. And you'll see the point about no absolute certainty. This comes from Advocate General Cocotte, where she says that it can't be construed as meaning absolute certainty. The conclusion of an appropriate assessment is of necessity subjective in nature. Competent authorities can, from their point of view, be certain there will be no adverse effects, even though from an objective point of view there is no absolute certainty. And what Lord Carnwath said in Champion then is quoted, while a high standard of investigation is demanded, the issue ultimately rests, in this case, on your judgment. That's the approach of the precautionary principle. So it's not a reasonably high test, it is a very high test. And you'll see at subparagraph 8, that's then followed, the requirement that there be no reasonable doubt does not mean the reasonable worst case scenario must always be assessed, which was being argued in that case. However, Sir Keith then looks at the European Commission guidance. Where the available data are inadequate or non-conclusive, a prudent and cautious approach to environmental protection, etc., would be to opt for the worst case hypothesis. And what he then says is, it's not mandatory, what is required in law is a sufficient degree of certainty to ensure there is no reasonable doubt on the relevant question. It may be appropriate to consider a reasonable worst case, but that's a matter for your judgment. And 9 simply says best scientific knowledge isn't separate from the precautionary principle, but part of it. And then you see at 10, what is required, therefore, is a case-specific assessment, in this case plan-specific, in which the applicable science is brought to bear with sufficient rigour on the implications of the project for the protected site concerned. So I've simply trawled through this to show you that Mr. Bewley's, well, it's a reasonably high test, it's not absolute certainty. It is a high test, and absolute certainty doesn't mean that you can simply avoid the risks which are involved. And what he asks you to do is to make a whole series of assumptions, and he misunderstands the case against him. I will give you one simple example from his last edition. He says, our HRA doesn't consider cumulative effects. He just hasn't read it properly, I'm afraid. If you look at the section on the effectiveness of mitigation, which starts at paragraph, this is CYC 45, this starts at 4.2.121, which is internal page 88, PDF 90. It starts by commenting on them comprehensively. At 4.2.134, it says, for the sake of simplicity, it takes each of them and explores them one by one, but then comes back at the end on overall conclusions at 4.2.209, page 100 internally, PDF 102, to say, each proposed element of mitigation being considered in turn. However, this is not the best way to consider their overall effect. They are, after all, suggested as a package of measures, and as the debate above shows, many are interlinked. So there's no difference between us. Our HRA does consider the cumulative mitigation proposals. So we have a position where DIO simply hasn't read the material. Second point arising from the points Mr. Bewley made, the 400-metre issue, the cordon sanitaire point, is discussed in the evidence. The footprint report responding to the DIO material deals with it at, I think, section 7. It's PDF, it's CD45A, because there are a number of footprint reports you'll know dealing with each of the SACs. It's the one that responds to the DIO report, and it's PDF pages 205 to 210, which looks at the use of the 400-metre zone. And so the material is before you. It's helpful, I think, also when bearing in mind some of the claims that are made with regard to, well, the possibility of the master plan, etc., to look at the side-by-side comparisons of the two surveys. And you'll find that in CD45, Table 7 is a useful, it's more comprehensive than the agreed statement. Table 7, which is in the HRA pages 81 to 83, PDF 83 to 85. Now, Mr. Bewley suggested, well, of course, you can design the site so the houses are pulled back. But of course, the thing that you've got to bear in mind is that Strensel Common is attractive to people walking, and in particular to dog walkers. And I'm not going to be anecdotal, but having dogs myself, I could understand the question that you asked. This is a case where the evidence demonstrates that round about 3/4 of the visitors are spending an hour on the site. It's not just a quick dog walk, it's an hour on the site. 73% in the case of footprint, 71% in the PCP case. This is towards the end of Table 7. The percentage of interviewees who gave a reason for visiting because it was close to home is over 50% in both surveys. 51% for footprint, PCP even higher at 57%. It is simply an over-optimistic assumption to say that by putting 500-odd houses adjacent to Strensel Common, even if there is an open space buffer provided within the site as shown on the master plan, that it won't be regarded as close to home. And one road does remain, even on the master plan, clear through from Strensel Village to the Common, and you can see that marked in a white dotted line on the master plan. The fact is, it's close to home even for those who are not close to it at the moment. It does not require any major effort of the imagination to see, well, if you're putting 500-odd homes even closer, then its attractiveness is obvious. Mr. Bewley then says, well, it's only 5 dogs an hour, or 5 people walking an hour. Well, that's 60 per day, and 3/4 of them will be dog walkers on the current proposals. Footprint deals with those figures anyway, and it doesn't. Mr. Bewley, I know, noticed, was very careful not to say it demonstrated that those figures were footling. He didn't say that. He just, he sought to diminish them, but he didn't say they were irrelevant or too small to be of concern. Footprint addresses that particular problem in its section on predictions of future use in CD45A, the DIO report, and this starts at PDF page 194. And I'm not going through the details, you've got the documentation, but you'll see that the concern as to the level of increase predicted is a genuine one. and it refers to very high risks. And going back to Table 7, as I've said, not only do 3/4 of those surveyed take an hour on site, but 3/4 of those surveyed are walking dogs. You already have our position on the inadequacy of the SANGs. Wardening, we note, wardening tends to be used in connection with the provision of SANGs and a 400-metre exclusion zone. And you'll find that, for example, at the Thames Basin Heaths. To the extent it's relevant, I spent a lot of time helping them set up the policy principles with the local authorities in Natural England some years ago. It's got a combination of it has a combination of all particular factors. This does not propose a combination of factors with wardening. And one does point out the MOD could have wardened it in the past but hasn't. And whilst emphasis is placed on the bylaws, I'm not going to ask you to second guess the opinions from Mr. Bewley and Mr. Marici. I'll just make this practical point. The MOD is suggesting to you that having departed the locality and ceased active defence use of the site, it is going to be spending public money on enforcing the bylaws. That seems to us to be making a lot of assumptions. But in any event, the bylaws have not prevented incidents from occurring which are listed in Appendix 2 to the Statement of Common Ground. We don't accept their inconsistencies. You've got a series of reports from Footprint which explain the approach taken to each. I'm not going to go over those. Master plan. You'll see the white line I was mentioning and the road is marked with an arrow at both ends, connecting the common with Strensall Village, just to the northern part of the site.
Is that Howard's Road?
I think so. That's the note, penultimate bullet point on page 21 with the master plan on it. Yeah. And as for issues associated with the 400 metres, ground nesting birds, cat predation and the like, this is dealt with in the Footprint response to DIO. Our submission is simply that the approach that's been taken isn't consistent with principle. The master plan, as an example of what might work, does not work for the reasons we've set out in our various reports, and Mr. Fleming's explained in terms of the SANG. And even if one must look cumulatively at the various methods, there are significant flaws in many of the key elements of the mitigation, as pointed out by Mr. Fleming and as pointed out in the Footprint report. And you have a case where such evidence as there is, and we don't say that this is meets the high test, but such evidence as there is supports local usage, dog walkers, and remaining on site for a significant period of time. All of those factors suggest that by placing new housing so close to the site, even if you can't walk directly from your garden onto the site, no one's suggesting that's necessarily going to be the case, but even if you're going, even if you're looking for somewhere to take your dog for a walk, you're not looking at a 5-minute walk. The dog walkers seem to be there for a significant period of time looking at the survey evidence. And therefore the assumptions that are being made, even on the basis that you're looking at a plan allocation, not at a project, and so you aren't fixing it to specific details, and I of course accept Mr. Bewley's principle 5 up to a point, but we do say that doing the best MOD DIO has done, it does not eliminate the risk, which has to be approached with a very high degree of caution. And for those reasons, we say the answer from DIO does not deal with those risks sufficiently, and the issue remains in principle for this allocation.
I am aware, Mr. Good, that you've been indicating for a little while, but I'm going to allow Mr. Elvin and Mr. Bewley to thrash it out a little longer before coming to you.
If you had have come to me, sir, I'd have suggested you did that anyway.
Mr. Bewley.
More thrashing, I'm sorry. I've got 4 just very, very quick points. So on the legal test, I don't think there's anything between us. I don't think I did suggest it was a moderate test. If I did, pretty sure I didn't. Mr. Elvin's nodding at me. You'll have your note. It's not a moderate test, it's a high test. That's right. We don't shrink from that. There is no dispute between us as to actually what the test is. I took you to the passages which are the same passages Mr. Elvin did. High degree of certainty, no reasonable scientific doubt. That's the test. Call it high, call it low, call it what you like. That's the test. But there is a more specific point I want to deal with on the legal test, which is in relation to natural England. Now, Mr. Elvin takes you to passages from Wyatt, and they're reflected, although we didn't update with the Court of Appeal judgment, they're reflected in earlier cases, and it's in the Statement of Common Ground to similar effect, that you're entitled to, and I accept, should give significant weight to natural England. But it's very important to understand what that means. So certainly if you write a decision where you say we're not interested in natural England, that would potentially be an unlawful approach. What it doesn't...
Yeah, we're reasonably unlikely to say
No,
that.
well, quite. Would rather expect that. But what it doesn't do is to convert into the principle that Mr. Elvin suggested or hinted at, which is that you must accept natural England's view unless there's material before you that they haven't seen or something like that. They've seen the same material. As far as I know, they've seen all of the same material that you have seen. They've set out their view, although it's important to say in very few cases have they given much by way of reason, certainly in relation to the more recent material. They've just told you what their view is. They're entitled to their view. So in coming to your view, you must take account of their view, that is right. But having done so, you must, in my submission, exercise your own judgment on the material before you, and not be diverted into a question about whether there's a reason to depart from them which they couldn't have anticipated. That would turn them into the decision maker, not you. So yes, by all means, I positively invite you to give weight to their views. You must do so. They're the expert body, they're the statutory body. But you must come to your own view on a detailed analysis of the material. There's no room for sort of presumptions in favour of natural England in that sense.
So the view of natural England, you say, irrespective of the extent of reasoning given by natural England, is something that we must weigh in the balance,
yes.
But must give significant weight to the view of natural England in that balance.
You must give it significant weight, but you must set it against all of the other material considerations, the detail of the argument which you've heard, which I do suggest, at least in this case, goes well beyond anything Natural England would say. And quite how much weight you give to it will be a matter for your judgment, having regard to the level of detail of argument and analysis you've been able to do and what you can take from them. You're not bound by their view, which is where Mr. Elvin...
I'm not suggesting for a moment.
He may not have said it. He drove in...
If it helps, it's clear to us that we are not bound by Natural England's view.
No. But nor are you bound, I suppose the point I was seeking to make is, nor are you bound to identify some additional factor that they haven't considered or anything like that. You just weigh their view in the balance, that's the point. That's the first point, that's what I want to say about legal test. Secondly, I may be repeating myself, but Mr. Alvin said that I hadn't read the Waterman report. In fact, I drew specifically attention to paragraphs 4.2.209 and 4.2.210 in the Waterman 2020 HRA, which is where they say you've got to consider the mitigation effects of the mitigation cumulatively. I made that point. However, the point that we make about it is that when you consider in contrast to the overall discussion of mitigation, relatively short passages which follow, which purport to do that exercise, you don't see it being done. Certainly not in the way that I've invited you to do. What you see is, in fact, a default back to the idea of a 400-metre exclusion zone, come what may, rather than a kind of case-specific analysis of whether the mitigation will work in this case. That exercise isn't conducted. Whereas when you look at the individual, the consideration of the individual measures in the paragraphs which lead up to 4.2.209, what you see in each case is an explanation of why that doesn't do the job by itself, which in a sense was just not the question. No one's saying we'll only have one of these mitigations, and no one's really saying that one of these by itself would work, because any one of them by itself would leave gaps elsewhere. The green space doesn't stop you getting onto the common, the fencing doesn't give you a reason to stay within the site, and so forth. You have to take them together. And you don't see that analysis. Thirdly, Mr. Alvin said that there was evidence before you to support the 400-metre exclusion zone, and he went to, which is where I would expect him to go to, the footprint response document. So this is the document which is, I'm sorry, I don't know the appendix number, but it's one of the appendices to, it's Appendix F to the Waterman 2020 HRA. As far as we can see, because he wasn't very specific at the detail, I don't think there is a section 7, but there's a section 6 where they justify the 400 metre, or there is a section 7, but they appear to justify the idea of the 400 metre exclusion zone in section 6. In particular, under the heading, the potential for mitigation for development within 400 metres, that's the heading, so that's addressing that issue. But if you just read it, and I won't read it out now, you'll see in particular, for example, 6.11 and 6.13, that what they're saying doesn't actually support the idea of a 400-metre exclusion zone, come what may. It supports the idea, which I would not have a difficulty with, that when you're within 400 metres of a site like this, you need to look at the matter carefully. Well, we're not suggesting otherwise. We say you look at it very carefully. We say that's why we're here, in a sense. But actually, so for example, 6.11, the policy that's quoted from Rushmore Borough Council is a policy ultimately that if you're within 400 metres, you ought to consult Natural England, not you shouldn't have development. See also 6.13, where you see the same analysis in terms of the problem with being within 400 metres, being that walkers can go directly there and they don't have a long, they have easy access. Now, obviously, if you've addressed that via your mitigation, that sort of reasoning doesn't apply. It's about walking distance, in other words, not distance as the crow flies. So it doesn't support this generic approach, which ultimately we suggest is the key to the Council's approach. Last point is on...
Just bear with me a minute, Mr. Beale.
Yes, of course.
Yeah, forgive us. If you could just make that last point again.
I'm so sorry. So it really arises from the previous point. So when you look at the way that the council, or sorry, Waterman I should say, in their HRA, the paragraphs following 4.2.209 deal with the cumulative benefits of mitigation, we say that what they actually do, and you'll read it for yourself and form your own view, what they actually do, rather than considering the effects, the cumulative effects of these mitigation measures taken as a package, what they do instead is that they fall back on a much more general idea that mitigation just can't work if the development is within 400 metres of a heathland SAC. So one then asks, can we find evidence for such a blanket approach? In relation to that, as I understand the way Mr. Elvin puts it, he says, yes, you do find evidence for that, and the reference he gave you was to the footprint response document, which is one of the appendix F to the Waterman 2028 HRA. And it seems to us that if that does do that job, or something like that, the analysis is to be found at beginning at 6.11. The point I make about that is that when you actually look at what's said there, it doesn't support a general rule that development within 400 metres of a heathland SAC will necessarily cause problems or will be incapable of mitigation. All that it supports is the idea that there may be problems which will need careful handling. So, since you've asked me, let me just read a bit of 6.13. Mitigation approaches such as access management and wardening are likely to be less relevant to development in close proximity to European sites, as it is harder to intercept visitors, well, it probably is harder to intercept visitors, who enter from multiple informal access points, e.g. back gardens, and are likely to use the heath at a wide range of times. Such use will be by people who have the green space literally on their doorstep. So that's flagging up an issue. It's not saying you can't mitigate those issues, because obviously if your back gardens don't back onto the development, that problem that's highlighted there of informal access points doesn't arise. If you've got a secure line of fencing and a limited, in this case effectively only one access point, there's another one slightly further away at Scotland Creek, but I mean it's even further away, then you deal with the problem of multiple informal access points, and you deal with the idea that it's on the doorstep. It isn't, for practical purposes, on the doorstep. So what it doesn't do is support a general rule. It supports the proposition that you have to look to see what mitigation can deal with the problems. And it doesn't deal with this case, where we've set out a very extensive range of mitigation measures, which, on the face of it, will do that. And there's no actual explanation of why, taken as a package, they won't do the job. That's how we're going to look at it. Sorry, a longer answer to the question, but I hope that makes it clear. Yeah. Sorry, just the last point. Mr. Elvin made a point about DIO not remaining on the site, which, as I understand it, goes to both wardening and bylaws. I just want to be clear about what DIO are and are not doing. Obviously, they're not subject to, once this is developed, remaining on the QEB site. They certainly are remaining as landowner of Strensall Common, of the SAC, which, by the way, is still in use for military purposes, which is a site, precisely because of its status, SAC, etc., is not going to have any development value in its own right, and which is subject to an act, the Strensall Common Act 1884, which gives them powers in perpetuity. So they do have to remain there, and that's the context in which the bylaw making power exists. So it's just wrong to think that we kind of walk away from all of this we retain ownership of the common, and indeed quite a lot of other land nearby, I might add, but critically the common. That's the critical point when you're thinking about the realism of bylaw making powers in perpetuity. And obviously, therefore, in that context, it can be made subject to Section 106 agreements and all the rest of it, provide wardening in perpetuity, just like any other landowner. Would it cost money? Yes, it would, but obviously, this is a valuable development site, so.
Is that to say that if we thought it would be necessary for the bylaws to be tightened in some way, and an example you gave earlier was requiring dogs to be kept on leads?
Yes.
If we thought that something like that was necessary, I think what you're suggesting is that that can be secured through a legal agreement alongside a planning application. Is that right?
Yes, we think we can. Certainly wardening. But of course, in relation to the site itself, the Secretary of State has ongoing duties as a public body in any event. That's in relation to the common itself and in relation to the exercise of bylaw making powers. So, yeah. So those are the points I wanted to make.
Is Mr. Bewley really saying that the Secretary of State would bind himself in a 106 agreement to change bylaws when he's got to take into account other public law considerations in making those bylaws?
No, but he can bind himself in relation to making provision for wardening and the like. I'm not saying you can do this, sorry, I'm not saying you can do bylaws by the Section 106. I think that would not be right, yeah. But
Understood your question.
yeah.
Yeah, I just wanted some, because I'm not clear about what the mechanism would be.
No, but the Secretary of State will be, in all reasonable foreseeable circumstances, the owner in perpetuity of the common. He's got powers in perpetuity under the Act. And since he's the landowner, he's got obligations to the site in any event. So it is quite important we're dealing with a public body, and a public body who has those wider obligations. The bylaw making powers are themselves provided in order, even long before this was a European protected site, to protect, among other things, see Section 6.3 of the 1880-84 Act, if you need to, and it's set out in my recent advice, for the protection of the for example, things growing on the site. So there's no doubt that the bylaw making power can and should be exercised in those ways.
Yeah, sorry, it's maybe me, in which case do forgive me. I don't know if you quite get the point, Mr. Griffiths, but either way, just so I'm clear, yes, the Secretary of State does have bylaw-making powers in relation to some of the things that you've mentioned. He hasn't thus far used those bylaw-making powers, and my question, to put it bluntly, is if we thought it was necessary, how could we make the Secretary of State do that?
First of all, we're not dealing with the plan. So get back to the point that we're at the plan-making stage here. So I suggest it would be better left to a planning permission. I don't think you can do anything in a local plan, but provided you're satisfied it can be done at the the planning permission stage, that's sufficient. Secondly, a planning permission would only ever be granted on the basis that there were sufficient certainty about the measures that the Secretary of State would have put in place. And if the Secretary of State, for example, indicates to public inquiry, as it may be, an intention, or to the Council, an acceptance that those bylaws need to be made, and this is a worst-case scenario. I mean, it's not completely clear they would have to go that far. The existing bylaws may prove to be sufficient. Then that's a matter the local authority or the planning permission inspector would be entitled to have regard to in considering whether to grant planning permission, and considering whether he was satisfied that the necessary certainty had been reached. Yes, I mean, please do. Sorry, say yes. Oh, sorry. I thought you wanted to ask me a question.
No, you carry on.
I wasn't going to add anything, but
We just wanted to be absolutely clear
Yeah.
about this situation. It's what you're telling us, that it's not the requirement about the bylaws.
Yes.
If we thought that might be necessary, it wouldn't be something we could do at plan.
No, it wouldn't be at plan
this
making stage, that's right.
It would be something that would have to be done through a subsequent planning application.
Yes, correct. Correct. But you can be satisfied that that can be done, or that an inspector, if it were an inspector, would be entitled to take account of that.
Yeah, but if it's not being... We agree that it's not something that we require at a plan-making stage, but nonetheless it is something that feeds into the justification, potentially, depending on what we think about the impact of the development. So what I'm not clear about is, at the planning application stage, how the decision maker, whether it's the council or an inspector, could require changes to the bylaws, or would that decision maker be reliant on that being put forward as part of the package of measures, or what?
It would be. It could, for example, it could be put forward by DIO. It could be put in place.
What if it wasn't, but the decision maker thought it was necessary?
They'd be entitled to refuse planning permission, knowing that those measures are in principle possible, but aren't on offer. Just as you can. I mean, you know. In principle, that's no different from any other measure which is suggested by mitigation. You assume, for the sake of this argument, allocation approved, planning application comes forward, decision maker thinks that whilst it might be possible, consistent with the local plan conclusions, that the development could be done in a way that satisfies the habitats regulations, but the mitigation measures that are actually on offer at that stage are not sufficient to do that. So they could be, but they're not. You can refuse planning permission. There's no difference with the bylaws in that regard. Yeah. I mean, in principle, it's a matter that knowing that it can be done, a planning decision maker is fully entitled to say it can be done, it's not being done. I mean, this is all a bit fanciful in my submission, because it's fanciful. I suppose the DIO, if he accepted the need, wouldn't do it. And I mean, one has to look at the real world as well. But knowing that at the theoretical level, knowing that it can be done, concluding that it's necessary, i.e. that it would make the proposal acceptable, but it's not offered, the planning inspector or whoever it is entitled to say no.
What I've just looked up are the tests in the framework. I've got an old
I haven't got it in front of me,
framework in front of me, but I don't think the tests have changed. If the decision maker at planning application stage thought that some change to the bylaws of that sort was necessary to make the development acceptable in planning terms, then it would be a reasonable obligation to require of the Secretary
you would expect them to do it. Now, query whether you do it by planning condition, you probably couldn't, but nevertheless you could refuse. Unless and until it was done, you would be entitled to refuse. That's the short point.
I understand.
Yeah.
That's helpful.
Yeah, thanks.
Well, if we're talking about fanciful, can I suggest that DIO's proposals are fanciful? Firstly, they have not done this to date, despite having had control of the site for many, many years. Even when the site was in unfavourable condition, they didn't ban dogs without leads. Secondly, there are serious practicalities of enforcement. This is a virtually 600 hectare area. The exact SAC, it's 569.63 hectares in the notification document. Thirdly, how you prevent dog walkers letting their dogs off their leads over 600 hectares is not only an enforcement question, but it goes to the reasonableness of the powers. The whole point of using SANGs is to induce people to go elsewhere. And as the footprint report makes clear, the wardening measures are used in conjunction with SANGs and the 400 metres boundary. Mr. Bewley is not fairly reading the footprint report. I'm not going to go through section by section, but I'll ask you to read section 6 yourselves. I will point out the fact that the reference to back gardens is only an example, and he is reading it wholly unreasonably, because it's about having the site on your doorstep, not literally, but meaning close at hand. And if you read the paragraphs of footprint in section 6, Mr. Bewley is quite right, it's section 6, the detailed discussion starts at 6.4. It's quite clear that it's proximity that's the issue, not direct from your garden. And interestingly enough, he was reading out chunks of that report. The Rushmore quote that he referred to at 611 actually says unlikely to be permitted within the 400 metres, and you need to discuss with Natural England, not just that it's down to Natural England's consultation. You will see the general material about distance at 614 and thereabouts. You might also want to note at 616 that it was thought that a 9% increase in recreational visits in Cannock Chase was sufficient to trigger the risk, let alone the higher percentage proposed here. But in any event, I do ask you just to look rather more carefully than Mr. Bewley has at section 6 of the footprint report. The other point to bear in mind, although it's not in evidence, but it's Mr. Bewley's majoring on what he can do with bylaw amendment in future, is please note that there is military use on some of the other protected sites, like Dorset, and the 400 metres zones are still applied. And as far as we're concerned, the absence the proximity of this site to the protected area without a 400 metre zone would be unusual, if not the sole example. You'll have to see what footprint says about that. I've already made my point about the HRA. It is a distortion in my suggestion that they don't look at cumulative properly. And I ask you to read the overall conclusions again, which makes it clear, fairly read, particularly since it says at 4.2.210, even if all were implemented, and it's not clear that they would, it remains doubtful whether they would provide the level of certainty required, etc. There you go. Other than that, I think I've made my point. Of course, I wasn't suggesting that Natural England take away your decision-making powers. What I was drawing attention to was the fact that Mr. Bewley can't point to anything in Natural England's approach which suggests that it hasn't been fully aware of all the issues that are also before you. And let's bear in mind that they're also signatories to the Statement of Common Ground, so they're fully aware of all these issues. That doesn't mean you have to agree with them, it just means you have to attach significant weight to their views. Of course, it's your decision at the end of the day. Thank you.
So, yeah.
Yeah, are you close to having said everything that you'd hoped and dreamed you might be able to this morning, Mr. Bewley?
I was going to say, so last thresh, I think was the two really quick points. Section 6 of the footprint response report is the one we've been talking about. The short point, when you read it as a whole, is that it doesn't support the proposition that development within 400 metres of an SAC or a heathland SAC is necessarily and for that reason to be ruled out. It supports the proposition that that may give rise to problematic issues which will be needed to be considered on a case-by-case basis to see whether they can be mitigated. So look at this case, not those cases that are referenced, which are different sites with different characteristics, different protected species. Look at this site and ask the question, can the problems identified by Natural England or the Council be mitigated here? You do that exercise not by reading footprints consideration of other sites, but by looking at the package of mitigation measures on offer here. That's the first point. The only other point, very briefly, no DIO have not made more extensive bylaws in the past. We know that the site actually improved its condition over the last 10 years. The simple point is if, and it is a big if, we're not by any means on our side convinced you would need to put a rule about dogs on leads. If you need it, it's there. And of course, the bylaws which do exist can be taken to be having some effect. We're not talking about hardened criminals, we're talking about dog walkers who see a sign and know that they're liable to a fine if they don't do it. And the question is, does that affect their behaviour? And you don't have to know that you enforce every instance of breach. As I said earlier, it's a numbers game. So are the bylaws likely to be effective in that sense, in changing behaviour? Whether in their current form or in a different form, I respectfully suggest yes, must be so, just as they are at the moment in that sense. That's it.
Mr. Elwyn.
All I'll ask you to do is note this. Footprint were not looking at this in a vacuum or in the abstract. They were looking at it in the context of the DIO response. And all I ask you to do is read the section and look then at the conclusions, which are in a green box called key points, following 6.22, and ask yourselves the question whether Footprint were directing themselves to this specific case or whether they were dealing with an abstract issue. Thank you.
I'm wondering, Mr. Good, that whether, despite your admirable patience, whether the point that you wanted to make was a lengthy one, or whether I should take a break for lunch now.
I can assure you, sir, it won't be as lengthy as the discussions we just had.
Well, that doesn't narrow it down.
It narrows down slightly, sir, but maybe not as much as you would like. It won't be overly significant, sir, in terms of the length. I'm happy to wait, however, if you are desperate for lunch.
Desperate for a break, anyway.
We were just wondering whether it would be better to have a short break now and carry on until we've completed this hearing, or whether there's enough left in the remaining questions to justify a proper lunch break and then coming back afterwards.
It's the proposition of a snack rather than a three-course lunch, I think, that Mr. Griffiths is putting forward.
Does anyone have a strong preference?
If it helps, my understanding, and I think this is common ground, is that what we need to deal with on Greenbelt is really pretty quick. I mean, I know we may take that with a... Yeah.
Bewley saying he's happy with the snack.
Yeah.
Yeah. Yeah, maybe come. Okay, we'll adjourn then. What we'll do is, I'm one for compromise, so let's say 25 minutes,
Yeah.
1:15, and then we'll resume and we'll go from there to completion of this hearing.
Yeah.
Okay, until 1:15. Thanks, everyone.
Thanks, sir.